that they would, I guess they intend to get from Ms. Hurd is that she either wrote it or republished it.
Yeah, what happened the next day is Ms. Hurd posted it on her Instagram account and said, look what I published yesterday in the Washington Post. So she adopted the title, and her name was on the article which contained the title.
And Mr. Ronborn, the only reason I'm sorry to interrupt you, only because I know that was a stipulation, so it's hard for me to say that that's all the evidence for motion to strike if there's a stipulation that they're still going to get more evidence in on that particular issue.
I think, and I'm happy to hand the court the transcript of the April 8th hearing, because one of the things that we're not arguing today is that because they haven't put in evidence of the, I think it was a tweet, but Mr. Chu says it was Instagram, I don't know, whatever it was, that because there was...
It was a tweet adopting the op-ed she published the day before in the Washington Post.
Okay.
All right, so what I'm not arguing today is that because they haven't gotten that tweet into evidence or had Ms. Hurd say that she tweeted that we're entitled to summary judgment at this point. I'm not arguing that, but that's all that we discussed on April 8th, and I'm happy to hand the transcript up, Your Honor. And we actually never, it wasn't a stipulation, it was simply an agreement that they didn't need to call her in their case in chief to make that point. And then Ms. Bredehoft said, we'd have to agree on the language of any stipulation, and they haven't proposed anything to us and haven't gotten back to us. So I think that that's only relevant. We're not basing our request for motion to strike here on Ms. Hurd not having testified to sending that tweet.
But you're saying for the motion to strike, the only evidence before the court is that the Washington Post wrote that title.
Correct, and that's very different from what happened the next day. The stipulation didn't go toward who wrote the title. That was never part of anything, and it's undisputed, and Ms. Hurd will testify that she didn't write the title.
Well, I understand that, but I
it's
think
not undisputed, Your Honor. I apologize for interrupting.
Okay. But I think the issue is that whether it was republication.
Well, and I'll get to that next.
But I know, but see, the problem is, how do I do a motion to strike when that evidence isn't before me yet?
Well, the republication isn't. So the evidence that's before you is that the Washington Post wrote the headline, or that Ms. Hurd didn't, and that's the only evidence, and that's not going to change. The tweet, which was the only subject of the discussion of the pretrial conference, where there was no stipulation, it was just an agreement that we're not going to base a motion to strike on them not introducing evidence of the tweet. That was what it was. I'm happy to hand the transcript up if Your Honor would like to see that. But that isn't actionable because under the Lakova versus Halper case, 995 F3rd 134, retweeting a link doesn't constitute republication. Now that case dealt with
it does if you add something to it, but I just don't know the evidence.
Your Honor, very quickly, it's a judicial admission. They admitted in Ms. Hurd's answer, she admitted to the tweet. So that establishes that she adopted the op-ed in its entirety, and it was discussed. We talked about judicial admissions. One was the op-ed itself. The second, and this is reflected in the transcript.
Your Honor, if I could finish my argument.